Page 143. BPD fails to investigate complaints in a timely manner or with effective techniques. When investigations of complaints do proceed, they are hampered from the start by poor investigative techniques and unreasonable delays. These failures limit the department's ability to discipline its officers by preventing investigators from collecting evidence of misconduct and subjecting evidence to attack during administrative proceedings. Delays impede investigations. BPD's misconduct investigations are frequently plagued by delays that compromise the evidence gathering process and undermine community confidence. As an initial matter, even when BPD's nominally accepts an external complaint and assigns the case to an investigator, the department's practice in most cases is not to investigate that complaint until the individual appears in person at BPD's internal investigation division during business hours and participates in a formal taped interview. By that point, key evidence that could have corroborated claims may be lost or destroyed. We found instances in which investigators waited months before canvassing neighborhoods in which alleged misconduct occurs. After such delays, physical evidence is often destroyed, witnesses cannot be located, and witness memories have faded. Other important evidence, such as surveillance video, may also be unavailable. These delays not only impede effective investigations, they communicate to the community that BPD does not take complaints seriously, even those alleging egregious officer behavior. For example, a man alleged in 2013 that two plainclothes officers punched him in the face, placed him in a chokehold, and spit in his face during an arrest. The man whose arrest prosecutors declined to pursue participated in a formal interview at IID during which he provided the investigator with the name of a witness to the incident and the witness's wife who could help investigators locate him. Excuse me. The investigator made no effort to follow up with the civilian witness until 8 months after the incident occurred. At that time, the investigator went to the car wash where the witness's wife had been working at the time of the incident and was told by the owner that she was no longer employed there. The investigator then recommended to close the complaint as not sustained because without testimony from independent witnesses along with the officer's denial, there exists insufficient evidence to prove or disprove the allegations. BPD's investigation of a second 2013 complaint alleging serious misconduct suffered even longer delays. The complainant alleged he was hospitalized after two officers slammed him to the ground and unlawfully arrested him for hindering and failing to obey due to his refusal to leave the area while officers questioned his brother-in-law. The complaint was not investigated for 13 months while two command investigation units sent the complaint back and forth. After the case was rediscovered after an audit of IA Pro, it lingered for another 4 months before a supervisor finally assigned the case to an IID detective. BPD ultimately found the complaint not sustained for lack of cooperation when witnesses failed to show up for interviews 17 months after the complaint was filed. According to the investigative file, the department never interviewed the accused officers. In another egregious example, an investigator made minimal delayed attempts to look into a woman's complaint that two BPD officers fondled her when conducting a search and called her a junkie whore bitch. The investigator assigned to the case made no attempt to contact the woman until 4 months after she made these serious allegations. And at that point, the investigator merely sent the woman a certified letter seeking information. 2 months later, after the letter had come back unclaimed, the investigator went to the residential address the woman had originally provided, only to discover she had been evicted months before. Moreover, the delays precluded investigators from identifying relevant video evidence. The incident occurred in a public location, the Lexington Market, that was likely captured on video surveillance. Yet the detective made no attempt to gather the footage until 10 months after the incident. By that time, any video had been deleted. Investigators also waited 10 months to reach out to a witness even though the complainant had provided the witness's contact information at the time she filed the complaint. Ultimately, the investigator learned that the complainant had passed away several months before he first contacted the witness. BPD then found the complaint not sustained. BPD uses ineffective methods to investigate misconduct allegations. In addition to frequent delays that limit the information available about misconduct allegations, poor investigative techniques further compromise BPD's investigations. We identified several key failures that recur throughout the department's investigative files, including the failure to adequately consider inconsistencies in investigations, as well as inappropriate interviewing methods and notice of allegations. First, investigators failed to adequately consider evidence and statements from witnesses or other officers that contradict explanations provided by officers accused of misconduct. Indeed, BPD appears to apply a standard that favors officers when evaluating statements made by complainants and involved officers. When BPD's Internal Affairs Manual encourages investigators to be wary of a complainant's inconsistent statements, the department permits officers to submit affidavits that clarify their original statements. And when inconsistencies arise, either from such addendum or other evidence, investigators generally discredit or discount entirely evidence contradicting the accused officer's account. We found investigations in which this took place even where the accused officer's account is contradicted by physical evidence, including photographic or video evidence. Second, BPD's investigators compromise officer interviews by failing to probe beyond reports that accused officers already provided and performing unrecorded pre-interviews with accused officers. As we described in Section 2C5, regarding forced investigations, these pre-interviews compromise the integrity of an investigation. Similarly, we also found numerous instances in which officers reviewed their statements or administrative reports related to the incident before the interview, and the interview then consisted merely of the accused officer orally reciting his administrative report. IID investigators did not probe beyond this oral recitation. These interview techniques inhibit the function of IID investigators to obtain reliable information from officers accused of misconduct. Third, BPD risks compromising investigations by providing accused officers with a detailed notice describing the alleged misconduct, often right after a complaint has been filed and before any investigation occurs. While LEOBR provides the officers must receive basic notice of allegations and 5 days to obtain counsel prior to questioning, BPD frequently notifies officers almost immediately after the department receives a complaint. This notice often takes place before a detective undertakes any investigation or attempts to contact the complainant to set up an interview. Moreover, the notice specifically articulates the allegations against the officer, sometimes including the date and time of the incident in question, providing such detailed notice at the onset of an investigation which is not required by LEOBR may compromise certain investigative steps and opens the possibility that a complainant may be retaliated against or intimidated prior to speaking with investigators. Indeed, the department's own internal affairs audit identified these same potential problems in 2014. The department nonetheless continues to use its early notification practice. BPD fails to adequately supervise investigations. The deficiencies in BPD's investigative techniques persist in part because of its ineffective supervision and training. Indeed, we found that most investigators receive no formal investigative training. Lack of training coupled with minimal supervision results in some investigators continuing to rely on poor investigative techniques. For example, one CIU detective who was responsible for all command investigations for an entire district told us that his practice was to allow accused officers to be interviewed by questionnaire, which officers could complete off-site with the assistance of their attorneys, rather than submit to in-person interviews. Although BPD formally discontinued the use of written questionnaires years ago, the practice persists because of inadequate training and oversight. Indeed, this practice has continued even after it was criticized by the department's own internal affairs audit. BPD fails to sustain complaints and apply discipline consistently. Deficiencies in BPD's complaint intake and investigations contribute to BPD's extremely low rate of sustaining allegations of officer misconduct, which in turn leads to a lack of discipline and accountability in the department. Discipline for allegations of serious misconduct is rare. Of the 1,382 allegations of excessive force that BPD tracked from 2010 through 2015, only 31 allegations, or 2.2%, were sustained. These allegations arose out of 14 separate incidents. In light of the significant evidence of excessive force we found in our investigation, the low rate of sustaining excessive force complaints is troubling. Similarly, BPD completed investigations in 1,359 allegations of discourtesy from 2010 through 2015 and sustained just 2.6% of those allegations arising out of just 15 incidents. This low number of sustained outcomes is also concerning considering the number of community members we spoke to described BPD officers behaving in a rude or abusive manner during encounters with community members. When complaints of misconduct are sustained, however, the trial board process that follows in order for discipline to be imposed also has several problems that impede accountability. First, the process is beset by delay. The department reported to us, for example, that some trial boards conducted in 2015 were to resolve cases BPD began investigating in 2011. Delays of this magnitude send a message to officers that misconduct is tolerated, frustrating officers and supervisors who are trying to follow and implement department policies and procedures. They also signal to the public, and in particular to the complainant, that officers who commit misconduct are unlikely to be held accountable. Second, officers facing the trial board have substantial powers granted to them by LEOBR and BPD's collective bargaining agreements to shape the membership of the trial board that will hear their case, undermining accountability. Trial boards convened by BPD to adjudicate allegations of misconduct are typically composed of 3 officers selected from a pool determined by the commissioner. Under LEOBR, each board must include 1 officer who is the same rank as the law enforcement officer against whom the complaint is filed. The accused officer has the right to reject assigned board members a total of 3 times through the use of preemptory strikes. The officer can exercise these strikes up to and including the day of the hearing itself, potentially dismissing all members of the board. We heard from numerous sources, including many within BPD and city leadership, that this use of peremptory strikes permits officers to assemble a trial board sympathetic to their interests, particularly because the pool of eligible command staff in the department is limited, because the command staff members are also part of the same union. BPD lacks effective civilian or community oversight. BPD's accountability system is shielded almost entirely from public view, and the civilian oversight mechanisms that are currently in place are inadequate and ineffective. These flaws damage the department's legitimacy in the community. Community members are unable to obtain information about BPD's complaint and discipline system at almost every step in the process. Complainants face many hurdles in filing complaints, but once they are filed, it is difficult for complainants to obtain information about how the complaints are progressing or whether and when they will be acted upon. Indeed, even when discipline is imposed, notice of this action is only given to a small group within the department, not to the complainant or to the public, except in unusual circumstances where the department determines that a broader announcement of the discipline is in the public interest. Trial board proceedings have been closed to the public historically. Although they were open to the public in early 2016, it is too early to determine what effect this has on the community's ability to affect the accountability process. The Maryland Public Information Act further limits BPD's transparency to the public. The Act prohibits disclosure of documents that constitute personnel records. The statute does not define the scope of this prohibition, but Maryland appellate courts have held that it applies to all materials related to hiring, promotions, and discipline, as well as any matter involving an employee's status. We heard from numerous sources that this provision has repeatedly blocked attempts to access information about the resolution of complaints and other issues of public concern related to BPD's policing activities. In addition, Baltimore Civilian Review Board has proven to be ineffective at changing this dynamic, in large part because it has never been provided with adequate authority or resources to perform its intended function. Established in 2000, the board was meant to be a crucial check on police misconduct by providing an alternative investigative and review process. The board is made up of civilian representatives from each of the city's 9 police districts selected by the mayor and approved by the city council, along with members without voting power from local advocacy organizations and a local chapter of the Fraternal Order of Police. The board may accept complaints that allege excessive force, abusive language, harassment, false arrest, and false imprisonment directly from the community. BPD is also required by policy to forward all complaints containing these categories of allegations to the board. The board may review BPD's investigations, or it may conduct an independent investigation and make recommendations directly to the commissioner that the complaint be sustained, not sustained, unfounded, or exonerated. It can also request that BPD undertake additional investigation. The board has faced several impediments to serving as a meaningful community backstop for accountability. First, the board relies upon BPD to forward complaints that fall within its authority, except when a complaint is filed directly with the board. And BPD often fails to forward complaints in a timely manner. Indeed, CRB staff members told us of cases BPD forwarded to the board only after BPD had already closed its investigation, despite BPD's obligation to share the complaint with the board within 48 hours of receipt. The board has no authority to audit BPD to determine if it has received all the complaints that should have been forwarded to it. Second, the board has insufficient resources and authority to conduct its own investigations. During 2010 to 15, the board only had a single investigator to investigate all the complaints that fell within its authority. The board also cannot compel officers to participate in investigations. Indeed, LEOBR provides that sworn law enforcement officers can only be interrogated by other sworn law enforcement officers. Finally, when the board makes recommendations to the commissioner about investigative findings or recommends that the IID conduct additional investigation, the board has no way of knowing if BPD acts on its recommendations, much less requiring that BPD do so. The lack of resources and authority that the city currently invests in the board renders it ineffective, heightening community perceptions that BPD is resistant to accountability. BPD's internal culture is resistant to effective discipline. The long-standing deficiencies in BPD systems for investigating complaints has contributed to a cultural resistance to accountability that persists in the department. The cultural opposition to meaningful accountability within the department is reflected by the lack of discipline for serious misconduct and widespread violations of minor policy provisions. The failure to take action against officers with a known reputation for repeatedly violating department policy and constitutional requirements, and a reluctance of officers to report observed misconduct for fear that doing so will subject them to retaliation. BPD has allowed violations of policy to go unaddressed even when they are widespread or involve serious misconduct. BPD has failed to take action against offenders known to engage in repeated misconduct. Our investigation also found substantial evidence that BPD fails to take disciplinary action against officers BPD knows have engaged in serious or repeated misconduct. One example of this problem is the so-called do not call list. BPD has had notice, including from the state's attorney's office, that particular officers may be engaging in behavior that is, at a minimum, unethical and impacts their credibility and integrity. Through at least 2011, the state's attorney's office maintained a formal do not call list of officers prosecutors would not call to testify because they believed their testimony would be undermined by issues of credibility or integrity. The size of the list varies over time and included as many as a dozen officers. BPD was aware of the list. The state attorney's office regularly discussed the officers on the list with Chief of BPD's Office of Professional Responsibility, but failed to take action on the information. Instead, the officers listed remained on the streets, making arrests that could not be credibly prosecuted. At one point, we were told an entire squad's members were on the list, leading to a number of cases being dismissed. Although the formal do not call list has been discontinued, the state's attorney's office continues to discuss problem officers with BPD. BPD's officers are reluctant to report misconduct. Well, that goes without saying. BPD does not coordinate with other agencies appropriately, and that's been discussed before. BPD fails to engage in effective community policing. From participation in grassroots organization meetings to police department interviews, our investigation revealed a significant divide between the police and the members of the Baltimore community. Both community members and police officers expressed that the department has overly focused on narcotics enforcement, gun recovery, and clearing corners, even when such strategies are ineffective at addressing the community's desire to combat drug crimes and other enforcement priorities. Many officers openly admit that community relations are BPD's weakest attribute. Some supervisors noted that it is sad to see how many of the city's residents, especially those in low-income, predominantly African-American neighborhoods, hate the police. This divide is a significant impediment to constitutional and effective policing in the city of Baltimore. The relationship between the police and the community of Baltimore is broken. Well, that goes without saying. And that BPD has failed to implement community policing principles. And that is it.